All right. Um, Yokoso. Today's topic is USPTO forms, and we're going to discuss the declaration, assignment, and ADS forms. Sorry for skipping last week. Um, Hopefully we'll make up the difference soon. Today is for Buin and maybe paralegals. Not much substantive topics for Benrishi Toka patent agents. Today's more administrative. But first, I have to tell you some more about American culture. As I learn about what topics are surprising, um, as I learn more about other cultures, notably Japanese culture, I learn how different Americans are. And I have to explain why we're so different. So Americans are more individualistic than some people in other cultures like Japan. Um, One of my Japanese friends who kind of studies cultures was saying that we are like Western pioneers or cowboys. Even today we are like that. This attitude still affects our laws and views. And so, for example, our patent law focuses more on the inventors as individuals than on the employer of the inventors, for example. And that's of course why I'm telling you this. You'll see many differences today. So again, these are the three types of forms we're discussing, not substantively on the ADS. It's just kind of a high level view based on the question that um, led to this seminar. So what is the declaration? It's three specific statements basically. It usually only has three statements. Each of these statements is required. They typically don't say anything else. It says that I'll read them. The above identified application was made or authorized to be made by me. I believe I am the original inventor, an original joint inventor of a claimed invention in the application. And I acknowledge that any willful statement made in this declaration is punishable by fine or imprisonment or both. I've never heard of an inventor going to jail for this, by the way. But basically, the idea is that we want to know who to punish if the invention was actually stolen. Um, this punishment, of course, can make sense if the applicants are the inventors, but what about applicants who are corporations? Well, in America, it is often more difficult to punish an employer corporation than to punish an individual. So, we want to be able to pinpoint who is responsible for um, filing this application. And we also idealize personal responsibility, right? We're like pioneers, Western pioneers. So, we do everything ourselves. So in the case of corporate invention theft, we think the declarant, the person saying they're an inventor, deserves more blame than, for example, their boss who told them to sign the declaration, right? If the company steals an invention, we're not going to really penalize the boss who says just sign the form. We're going to say that, you said you invented it. You should not, if your boss forced you to sign it, he should not have done that. Or you should still say no. So we want to be able to penalize the alleged inventors. What happens if the inventor refuses to sign a declaration? Maybe we should talk for a moment why that might be. Um, the most common situation is as a roadblock to filing a patent application. Why would that happen? Well, in that case, maybe the inventor was fired by the company or is being treated unfairly by the company. And the inventor does not want to assist. The inventor has very limited ability to punish the company for their bad behavior. And so they refuse to cooperate on anything, including this declaration. Maybe they don't want any risk of going to jail. Again, I've never heard of that. Um, you know, it happens. Well, after the America Invents Act, a person to whom the inventor is under an obligation to assign the invention, for example, an employer corporation, can file a substitute statement under 37 CFR 1.63. There was a way to do it beforehand as well, but I cannot imagine there are many pre-AIA applications still pending. So most people just do that. The assignment's a little bit trickier though, right? On the previous slide, we saw that the ability to file the substitute statement requires the assignment. There has to be an obligation to assign. Well, where does that come from? And we'll talk about that on this slide. Well, of course, the original invention begins with the inventors, right? So even if the invention was made in the course of employment, in America, we still believe the inventors own the invention by default. My understanding is that in some countries, like Japan, I believe Korea is the same, there are laws, like federal laws, assigning the invention to employers. Because America is different, American employment contracts should address the assignment of IP rights. Like when you sign the contract, the employment contract, you should know what you're agreeing to because each company might be different. And we think this flexibility of the assignment is good. Maybe some corporations only want IP rights related to their business, and they would do that as a benefit to employees, right? If you are employing very creative people who might have a lot of ideas, maybe you don't want to ask for all of them. Maybe you only want some of them because that incentivizes, that encourages these types of people to come to your company. The company won't take all of your ideas. They'll just choose the ones relevant to their business. On the other hand, maybe some corporations want all of the IP rights, and that's fine too. But here we would expect the employees to receive higher salaries, right? Because there's a risk that if they create something that also belongs to the employer, we think this is typical for America, right? There's no federal law requiring the transfer of the IP. It's believed to be negotiated. Still, the USPTO prefers a case-specific assignment of rights. People wonder, can we even file an employment contract as an assignment? Yeah, you can. If it contains an assignment of rights, you can file a copy of the employment contract. I haven't done it I don't know if I've ever done it, to be honest with you. I probably haven't done it much, maybe at least for 12 years, and I wouldn't have had much reason to do it before then. But it is possible. Typically, employment contracts address other situations. It's an employment contract, not an assignment. So we'll have other topics as well, like compensation. Um, and so people, especially companies, don't want to disclose this as a public document. And so people don't like using the employment contract as an assignment. But if it is in the contract, this assignment is in the contract, this also gives rise to the ability to say that the employee was under an obligation to assign the invention to the employer, and therefore you can complete a lot of the other paperwork like the substitute statement in lieu of the declaration. So again, these seminars are nominally directed towards paralegals, but of course, um, that's it. Just because the paralegals complete the forms doesn't mean that the attorneys and Ben Rishi and Shizai Buin don't need to know this as well. And so one question I get is, Brian, how should we how should we arrange the declarations and assignments for the inventors to sign? Um, some people, well, we'll get to it. So there's a lot of different ways, right? You can have one assignment that has many blocks for every has a block for a signature block for each inventor. So if there's four inventors, there's one form with four different lines to be completed. Sometimes people prefer doing one assignment for each inventor. So there's, four different assignments in that case. Some people like separate declarations and assignments. The declarations typically use a USPTO form in that case. The assignments are typically drafted by the patent attorney. But of course, sometimes people like to combine them in a single document, right? Maybe we don't want to ask the inventors to sign twice. Um, there's a lot of, and then it depends on whether it's a combined one or not. Like, how many forms do you want to keep track of? Especially if the whole point is to have one original, right? Maybe you don't want to send your one original with three signatures of the inventors to your fourth inventor, and then he loses it. Um, and the answer is there is no one best combination of forms. Okay. What do I mean? Some people prefer stronger evidence of signature. If you think that this document is really going to be litigated and that you're going to be accused of forging your inventor signatures and that your, competitors will accuse you of things, you will want one form that's signed by everyone, and you'll probably one assignment signed by everyone, and then maybe separate declarations. That's difficult. That's inconvenient, and other people, but it's inconvenient both for in-house staff. It's inconvenient for the inventors. It's probably more convenient for attorneys. Um, and some people prefer inventor convenience, right? Just give one form to each inventor. They sign once. It's both the declaration and the assignment. They're done. Um, but it's easier to challenge those. I find that most people prefer the inventor convenience. Um, I mean, the reality is if your competitor is going to challenge these, your competitor is going to challenge them no matter what you give them. Whatever form you use, they'll just have a different approach probably. Uh, so I kind of prefer the, combined. I think a lot of people do. Brian, what's this ADS? It's a relatively new form that focuses on bibliographic information for the application. Uh, it was around a long time ago. I don't remember. I don't think it was common at my firm, my first firm when I joined. Um, at the time I joined. I think it was introduced just like a year later, but it's been around since at least 2009. At that time, law firms used their own ADS forms. The USPTO did not have a standardized one, and so there was no standard format. They kind of looked similar, but they all looked a little bit different. And not every law firm used them. A lot of people didn't. But eventually, the USPTO created a standardized form. So now we use that. Um, and since 2012, uh, submission of an ADS is generally mandatory due to the AIA, the America Invent. There's a typo. I'm sorry. It should say America Invents Act. Let me be a little bit more clear. I can't think of the exceptions to the ADS off the top of my head. Um, it's basically every application. There are rare situations where you don't need an ADS, but basically, the only one that comes to mind off the top of my head is a provisional application does not require one. So for non-provisionals, it's basically required. I think there is one more exception. What's the importance of the ADS? The ADS governs all other documents. Brian, what does govern mean? If information in the ADS conflicts with information in another document, then we use the information in the ADS. Okay, that's what it means to govern. That's the easiest one to change. Pardon me. That's the easiest one to change. Um, we just say it's correct. There's one major exception, and that is that conflicts between the ADS and the declaration are governed by the most recently submitted document. So if your ADS is filed first with one inventor name, and the declaration is filed later with a different inventor name, the declaration controls there. That is the true name of the inventor. So we have to update the ADS, but generally speaking, in all other situations, the ADS will govern the declaration. The ADS has the correct name, and if you don't like it, you change it there. You don't change it in, for example, um, a previously filed declaration. You don't change it in, um, I don't know, the like maybe the cover page of the specification or something. You don't have to change it there. Brian, is placing so much importance on the ADS good or bad? Um, I remember when I started, I hated the ADS. Now I love it. It's good that there is a clear answer. It's not itself good or bad. It doesn't matter which. It's good that there's one document and that it's clear. It really doesn't matter much, which document it is. Why is this so important? Well, for example, applications sometimes arrive with many different titles. Maybe the PCT publication includes a first translated title, right? Um, it's done by one firm, um, or maybe it's done by the International Bureau. I don't know who translates PCT publication titles. Um, Pardon me. All my publication titles are in English. Pardon me. Hang on one second. Maybe the translator, when it's being translated from Japanese into English, gives the specification a different second title, right? The translator doesn't necessarily have access to the RO 101 form. They don't, they might translate it a little differently. Maybe the declarations are signed with a different third title, right? Some in-house person translates it. They don't know what the translator is going to say it is. They're not looking at the RO 101. Maybe they're using a declaration from the original Japanese filing, whatever it is. I guess it wouldn't have a declaration, it'd be an assignment. So the question then is, what is the title of the application? And the answer is the title is the one on the ADS. That's how it works, right? When they conflict, the one that controls is the ADS. And that concludes today's topic. I'm sure we will have more seminars in the future on these topics, but today was just a brief introduction to address um, a particular situation that someone was having. Thank you very much. I'll see you next time.